I see.
All right, presentation's up. You can just go to the.
Yeah.
I want to welcome everyone. I believe everybody's in. We've got 73 participants including us.
I don't know. How do you,
Just want to welcome everybody.
I don't see what we're sharing. Right here. No, I can't see what, it's already shared. But I don't see it.
Just slight technical difficulty, everybody. We'll be right there.
Yeah, hang in there with us. We're getting the presentation.
Good evening, everybody.
Buenas noches.
What's the share? I'm not sharing this already. Hi, everybody.
And while they're working on the technology challenge that will soon be solved, I just want to mention to everybody that towards the end of the webinar, we'll place a link into the chat area. And when you click on that link, it'll open up a tab in your browser to fill out a brief evaluation. After filling that out, it will also have all of the speakers' contact information if you wish to be contacted about how they may be able to assist your associations. So if you don't see the chat area, click the little chat button now and it will magically appear on the lower right-hand corner of your Zoom interface. Back to y'all.
Yeah, just want to welcome everyone in. Thank you for your time tonight. Frank Valdez will get through introductions in just a moment. We'll have a presentation up and running here shortly.
Hey, Frank, Anita just texted in the Q&A. The Q&A is open. I don't know, Jeff, if that's something you can put the link in the Q&A, but she said chat is disabled.
Yeah, chat is disabled for everybody to chat with us, but we can send stuff
Frank,
to
I need you to
out
share
there.
it instead of me.
So the chat will be one way
Okay.
for us to send you the links. The Q&A is how you will
So
interact
can you put
with
the link in
panel
the chat and let me see if Anita can see it?
Okay, the link, the evaluation link is now in the chat.
Okay. Anita, I'm using you as my class pet. Ah, perfect. Thank you. Thank you. Hi, Dominic.
Working.
Okay, we're going to get started in just a moment while we're getting it set up.
Thank you, Frank.
Welcome.
Perfect.
Just
with regard to the Q, and I'll just mention now, with regard to the Q&A, it is obviously open. We have some 3 great topics that Dana and Frank and I will be discussing with you over the next hour or so. And so what we are going to encourage is if you have questions regarding the topics we're discussing, please put them into the Q&A section. If we grab them while we're doing our presentation, then we'll answer them during. If not, we will try our best before we all jump off in about an hour, say 7:15. Before we jump off around 7:15, we will try to answer all questions. But again, please keep them tailored toward the subject matters that we'll be going over, which we will get into in a moment.
Okay, perfect. Thank you very much, Michael. We want to also say people are always asking us, so you will get a copy of this presentation to your email. And if you are, oh, this is not a CE, so no. So just a copy of the presentation to your email for your reference. And you will have the contact information of all of us on this presentation. So if you ever have any future questions, we'll be happy to help you after this presentation as well. I'm going to introduce myself since we always assume that everybody knows us, but actually not everybody knows us. All 3 of us together as well. My name is Dana and I'm the CEO and owner of Next Generation Management Services. I came into this industry from the finance world. And today, Next Generation proudly serves over 7,000 doors, and we provide management and financial services. Next to me here is Kim. Hi. She is part of our team. She has been in Next Generation a little over 6 years. She started as an office manager, and today she's Chief Technology and Revenue Officer. And it's very important that she's here today because everything that we do, make sure we're in compliance with the statute. Kim implements it in technology to be accessible to the homeowners. So she is the expert to make sure our associations are in compliance with the law. Next slide, Frank, thank you.
Hello. Hey, everybody. Dana and Kim, I want to thank you for helping put this together. Mike Bender with K. Bender Rembaum and appreciate the opportunity to be a part of this roundtable, if you will, with you both and with Frank. For those who are not aware of K. Bender Rembam, a little blurb there is up for you. We are a full service for law firm representing community associations. It's all we do. It's what we do. Our website is kbrlegal.com. And that's where I would encourage you to go visit to learn more about us, the firm, what we do. And there's a bunch of free education available to you there. And if our firm can be of assistance to your community, you'll be able to contact us right through the website. Myself, a board certified specialist in condominium and plan development law. I've been practicing law since 1993, which makes it 31 years, which is crazy. 25 of those years have been in community association law, and look forward to speaking with you all, my fellow presenters for the next hour. Frank?
You, Michael.
All right. So hopefully everyone's hearing me. Frank Valdez, Regional Director in the state of Florida for Get Quorum. We're an electronic voting provider. You've got a great, by the way, team here tonight, everybody. So grab your popcorn, grab a snack, make sure you get an afternoon little latte. It's going to be a great presentation. My role with Get Quorum is to really implement electronic voting all throughout the state of Florida. My background is not only some experience in the property management industry, but I do serve on my own board of directors and have a state license with the DBPR to teach electronic voting CE course to all our licensed camps out there. So can't thank you enough. I work for Get Quorum. We're an electronic voting provider in the state of Florida and all throughout North America, serving over 2,500 communities. We've got over 30 industry experts. We're a Zoom ISV provider, and we provide electronic voting, a fully managed service for you. So here to help anytime.
Thank you, Frank. We're going to discuss today new website requirements and deadlines, the importance of updating your governing documents, and annual meetings and online elections. The way we structured it, it's a round table, which means that we can all discuss on the same subject at the time. Obviously, Michael here is the law, so he's going to give us the law section of this presentation today. We are the management company. We are the executors of the law, and how do we assist the associations to be in compliance? And then we have our lovely Frank that assists us to assist you to save money, streamline your processes, and really have a fair and honest elections and do any amendments for your associations. And again, thank you for joining today. Mike, I'm going to send it to you on the next slide.
Jump right in then. So we're going to, it's association records. And the first topic is really, we're going to focus on the website requirements. But initially, the reason, if you, Frank, you can go to the next slide. Okay. Because we want to make sure all of you are fully educated on what we're teaching tonight. I wanted to put these slides in the materials there so that you have this to take with you. I am certainly not going to read through what the official records are comprised of. That would not be a good use of any of our time. But this way, when you get the at-home materials, you will have this at your fingertips. So these next few slides all talk about what the official records are. And the first thing is for condominiums. The official records are comprised of the list that's on these next two slides, this slide and the next slide. And as you'll see, it incorporates all of your governing documents. It incorporates a unit owner roster, insurance policies, financial records, and accounting records, and it gets into more specifics. And if you move to the next slide, you'll see additionally management agreements, rental records, although you do need to be very cognizant of the fact that any information you obtain in a sale or lease process, other than the actual agreement itself, would be considered confidential record information, not open to inspection. Okay, so it also includes bids and board member education certificates. Okay, there's new education requirements for all board members. And that's not a subject for today. That's not something that we're getting into heavily today, but I do want to remind you, condominium board members, you have a 4-hour course that you are required to take, and you can take it either 1 year prior to the day you start serving on the board or within 90 days after you're elected or appointed. That's a new class. It was just approved by the division. My firm is one of those providers that is teaching the 4-hour class. I believe we have one in September 19th of this month. And so if you are a condominium board member, recently elected or appointed, or a board member who's been serving on your board since prior to July 1st, you still need to take this class. The law says that if you are a current board member that took the prior 2-hour class, you have till June 30th of 2025 to take the new 4-hour class. So I encourage you, there's a lot of new information and education. So go to our website and you'll see where you can register right online. Next slide. Okay. This slide talks about condominium, the records must be made, how long you have to maintain records, right? And it says what you have to maintain, the plans, permits, warranties, recorded governing documents, and all meeting minutes have to be retained forever. Okay. And as Dana and Kim can tell you, that's something that is very important for you to be aware of, and that your management team is aware of. You know, years past, it was a 7-year requirement. 2018, they changed that to forever. So you should have all minutes from 2011 going forward. Okay, and I know Dana and Kim, if you want to talk about how you guys recommend those minutes be retained.
Yeah, it's in the next few slides. We'll address that as well. Yes.
Oh, well then I'll keep going. All right, go back one slide. Go back for 1 second. Okay. You also have contracts that are retained for 7 years, but bids, once you've accepted a contract that you were required to have multiple bids on, those bids have to be maintained for at least 1 year after you've received those bids. Election materials, 1 year from the date of the election. Typically, it's up till you have the next election. And if you are voting on things other than elections, like amendments, things of that nature, they have to be retained for at least 1 year. I'll remind you that depending on the nature of the vote, you might want to keep the records for longer than 1 year. When I'm talking about amendments, or if you have an alteration vote, you might want to document these records, keep these records on file for more than a year, just in case someone questions or challenges. The new structural integrity reserve study and milestone inspection reports must be maintained for 15 years. Okay. Next. HOAs. Again, a list of records that must be maintained, and they are all for at least 7 years, unless your governing documents require a longer period of time. And in all of my years and all the HOAs we represent, I've never seen one HOA that has language in their documents that requires references retention of records at all, other than to mirror the statute. Okay.
The rule of thumb is always the longer term. So if the statute says 7 and your declaration says 8, you would do 8.
Correct.
Yes.
Correct. If the statute does say 7 and your declaration says 5, it's 7.
Right.
Good
Always
point.
longer
Good point.
term.
Next slide. Okay. Board certifications also are required to be kept on file for HOAs, and board members in an HOA, you also have new certification requirements. You need to be certified once every 4 years with this board member and education class. If you are if you're a board member who received prior certification, then if you had that in 2020, you need to be recertified in 2024. If you had it in 2021, then by 2025, and you have to take a new class. Ours is a 4-hour program. There's a lot of new material. The addition, both for condo and HOA, you have continuing education requirements as well. So in a condominium setting, it's a 1-hour class per year on legislative changes. HOA, if you have 2,500 parcels or more, it's 8 hours of continuing education. If you have less than 2,500 parcels, it's 4 hours. This 1 hour would count.
Board members, not managers.
This is board member education only. I'm talking about board member.
This is new, so I'm just.
Yep, brand new. This is all board member education we're talking about. I'm talking to you board members.
Yeah.
Okay.
I'm asking if you guys have that available yet, Michael, the HOA 4-hour class, or is that in the
HOA 4 class is where we have submitted. It should be approved hopefully any day, and we'll be scheduling it.
Thank
you. Dominic asked, can these records be kept digitally? And that is something that, I guess we're going to get into that a little bit more.
Yes.
Okay. But the answer, Dominic, is records can be kept digitally. One thing I want to point out, and if I'm jumping the gun, but there was one change in the law for condominium. Okay, and that change said that if you keep all of the records you're required to keep on your website, if someone makes a request to inspect records, you can direct them to the website, and that will put you in compliance with that part of the statute. They did not yet do that for HOAs. You can put them on your website and direct people to the website, but you still have to get with your association attorney to talk about what you still have to do. And I should also have pointed out up front, guys, I'm not giving you legal advice. This is informational purposes only. You should certainly be speaking with your association counsel if you need association counsel. I know a good one, but but otherwise, definitely get with your counsel. So please, this is informational. All right. Frank or Dana, if you want to add anything more to this before we jump into the next.
We're good. Keep going.
I'll cover this a little bit more when we talk about electronic voting, but make sure you keep electronic consents on file for owners. And again, we'll dive more into electronic voting, but I get that question every week. It's, hey, we're ready to sign up for electronic voting with you. We've previously had consents from owners taken care of. And when I just reconfirm with them, hey, do you have those records that owners did consent to electronic voting in the past, of course, prior to engaging with us, they can't find them, right? They're nowhere to be found. Make sure you're keeping records for your association, especially as it pertains to electronic voting. In my world, consents for electronic voting, consents for electronic notices, no doubt that will put you in compliance. If you don't have them, you've got to restart that process.
Right. And one of the reasons I point out, and Dana and Kim can piggyback on this if they'd like, is when you're doing amendment voting, especially if you're doing amendment voting that pertains to sale or lease restrictions. The way the laws read now in 718 and 720, depending on the nature of the amendment language, an amendment that does get enough votes to pass may only apply to those owners who have voted in favor of that amendment,
right? Or
an owner who's taken title to their unit or parcel after the effective date. So it's important that you keep a record of who's voted, so that if someone down the road says, hey, I tries to rent and they have previously approved the amendment, then you're letting them know that doesn't apply to them. But if someone hasn't voted in favor of it, it may not apply to them. So you need to keep track of that. Okay.
I always chime in here when I say, when we're talking about amendments and associations, amendment is when you're changing your declaration. It's a change to your declaration. You're changing the language or the provisions in that declaration. And when it comes to amendments, always refer to your attorney, because some amendments would be for the whole association and some amendments would be in reference to how it was voted for. And this is why we have to be very careful when we determine the amendments and when we educate the board and the association, how those amendments are going to affect the association.
Perfect, thanks. Okay, well, let's jump into website requirements real quick then. Okay, so there in 2018, they passed legislation that said in the 718 Condominium Act that on or before January 1, 2019, if you are a condominium association that has 150 or more units, you have to have a website. And the website must have an independent website, or have a portal that's operated by the association. And it basically has the ability to have I'll call it a password protected section. So some associations I'm aware of have a website that is open to the public. For whatever reason, they offer, sale, they put little sale listings, etc. But there has to be a way for owners in that association to then access a private, confidential area of the website, and that's where the official records are kept.
Yeah.
Okay. January 1, 2019. So if you're a condominium that has 150 or more units in your building, you should have a website.
Mm-hmm.
Okay. What they changed in 2024 is that they've reduced 150 to 25.
Yeah.
So if you are now a condominium that has 25 or more units, then that means effective January 1, 2026, you need to have a website. You have a statutory website requirement. And what that means is you have to make sure that your website is in compliance with the statute. Between now and January 1, 2026, if you have 25 to 149 units, you should have a website, and you should try to make sure it's statutorily compliant. If it's not, though, you would not be in violation. But as of January 1, 2026, you would be. Okay? And the association must ensure information and records not accessible to unit owners are not posted on the website. Next. This slide that you will get lets you know what's required to be posted on the website. And this applies to, hold on a second, Frank, go back one slide for a second.
You're ready. This one.
Okay, I apologize because I want to touch on based on the HOA before we move forward.
Yeah.
HOAs, most HOAs, and Dana and Kim, HOAs you represent, do they have websites?
Yes.
I was
Right?
gonna say that even if it's 14 units or it's 1,000 units, every single one of the associations we manage has a website.
Right,
With
and
the
I find that to
with
be
the
much more common in the HOA world, although these days almost every condominium has some kind of website too. But in the HOA world, website is not uncommon. The difference is, as of January 1, 2025, an HOA that has 100 or more parcels, actually it's 100, it's 100 or more parcels, must have a website and must post the documents that we're going to list on our next slide on that website. Okay, so again, you need to now be sure that your website is compliant with the new statutory change. And HOA, again, January 1, 2025. The new condominium, the reduction to 25 units or more, that's January 1, 2026. You have an extra year to make sure you have your site up and are in compliance. Okay, this slide we went through and actually, Dana and Kim, you want to go over this?
Yeah, so this, piggybacking off of what Michael had already said regarding the association records, we've summarized here what belongs to what homeowners associations are required to have and what condos are. Most of the required documentation on the website apply to both. It's in our best practice that even if statute doesn't require you to post specific documents on your website, we find it in favor of transparency and communication to post that information if it's available. So, for example, it's actually statutorily not required for bids and proposals exceeding $500 to be posted for HOAs, even though it's required for condos. But in best practice, we believe that you should be posting that for HOAs as well.
It's for us, the legislative change didn't really affect, because for us, we believe that the more you put on the website and on the app accessible to the homeowners, it serves you as a board member. You're more transparent, because a lot of the times the miscommunication comes with people not having access to documents and not understanding what's going on in their association. So we make sure that all of the documents of the associations are updated daily for all of our associations, so that if a homeowner has a question, he can actually go into the app and obtain those answers.
Great. And again, just reiterating, guys, the change that was made in the Condominium Act, and the reason why it's important that you are making sure all of the records that are required to be up on your website in the condominium is you get those requests, and this is something I'm sure Dana and Kim can speak to. Often those requests can take a lot of time away from the operation of your association, put a lot of time on your management team and on volunteer board members. So it's great now that in the condominium world, so long as you are doing properly putting your records up, that you can respond to a written record request by directing them to the website. And if they need a password, letting them know to contact you, and you give them a password to access it. I do want to just put a reminder, though, that was the good part of the change. Yeah. One of the things I'm not so thrilled with that they added in Tallahassee this past session is you have again, only condominium world, you have a checklist obligation. And the checklist requirement doesn't seem to go away if you direct them to the website. That's something we're going to have to work on in 2025. Yeah. But you have a checklist requirement that you have to have a checklist of that you've given which records you've given access to, that if in response to the request, and which records you didn't give access to. Presumably, you're going to give access to everything on the website that's going to be comprehensive and cover everything the statutes require. So that checklist can indicate we gave them access to everything. But you're going to want to communicate with your council and have your management team, I think, communicate with your council to make sure you're doing that new requirement correctly. Because what I don't want to have happen is you follow all the procedures for giving access to records except the checklist, and then suddenly those cottage industry of lawyers who get involved in this, or those few owners who are constantly doing this, go up to the division and say, hey, they failed to give me a checklist. I'm not sure how the division will respond to that when you've otherwise fully complied. But I just want to make sure that you're aware of this new checklist requirement as well for documents, even if you give them access to the website.
And why not comply if you can?
over communicate here. In our world, while it's not a website requirement as of yet, we'd love to see it as an electronic voting provider a copy of that electronic voting resolution for the community, right? Post it there. It usually speaks to the rules of engagement, how an owner opts into electronic voting, what the guardrails are for opting into electronic voting, opting out to electronic voting, right? And so you can always refer them back to the website as to number one, the resolution that passed by the board and the language in that resolution. Again, officially, as I know it today, not an official requirement, but very nice document to have on those websites.
Okay, next slide.
Okay, before you move to the next slide, I just want to, I'm reading the questions, and Christine had asked about if we're talking about HOAs. Christine, I hope that you've heard that there's been a lot of conversation that we've referred to HOAs. We talked about HOA, we've talked about official records and websites to this point, and we went over what official records need to be maintained for both the condominium and the HOA. We talked about website requirements for condominium and HOA. Okay, and I talked about the new education requirements for board members for condominium and HOA. So we are, please be aware, we are discussing both. And this particular slide we're on right now, if you look, it says, where it says in parentheses, both, it means obviously condominium and HOA. COA is a condominium association. HOA would be a homeowner association. So I just want to make sure that everybody's on the same page. So thank you for that question, Christine, but I want to make sure we're all clear.
Good stuff.
So what happens if we're not maintaining the website and we're not maintaining the records of the association? This is the number 1 question that gets asked when we explain that that's something that you have to be in compliance. So on the association side, when a homeowner does the document request and the association/management is not in compliance, there can be a fine. It can be a $50 a day up to $500. And if they're unhappy with the results, they can take it to litigation, and it can also add, other than the penalties, there could be attorney's fees associated with association non-compliance with records. What happens when management is not assisting the association to be in compliance with having the official records and the website? So as managers, we fall under the standards of professional conduct. Every single manager, every single management company. I put in the rules, so you can Google it if needed to read the whole thing if you're unhappy with your manager and you want to find out if he's practicing, standards of professional conduct. But they take these records very seriously. I can tell you, I've heard from the past, and maybe Michael can concur, it's one of the number 1 complaints on managers is not maintaining records for the association. I can understand why it's very important, because an association is a business. You are part of that business as an owner, and you have undivided share of all the elements. So you should have rights to every single document that is in your own business. So I understand why why the Tallahassee is very, but takes it very seriously to maintain these documents, and it falls under the managers as well. Any violations could be, there can be disciplinary measures for the managers or the management company.
And I will just chime in here. Yeah, because as some of you may know, and I've been serving on a legislative action committee through CAI for 15 years almost. And so, and each year we're up in Tallahassee and working with lobbyists, and we're talking with people up there. And one of the things that we've been told is the division reports their biggest complaint from owners is that they fail to get access to records.
Yep.
With respect, we represent in the range of almost 1,500 communities throughout the state. We work with a lot of management companies like Dana and Kim. And in my experience, that is not the case. I know that I have community, I've worked with Dana and Kim on this too. They'll reach out and say, hey, we've got this request. How do we properly handle this inspection request? And they give access to records. So, so it's unfortunate that I am sure there are some issues here and there throughout our state, but I don't believe that it's nearly the concern that some of these new legislative actions have taken. Like that checklist requirement is way over the top, in my opinion.
Yeah,
but it is that's why it's just imperative, though, that you do work with your board members, you work with your management team, and you work with your council to make sure that you are implementing the inspections properly and in accordance with the statutes, and so that you don't unnecessarily expose yourselves to these penalties, fines, and these attorneys' fees from those attorneys who are out there trying to grab some fees for failure, for people fail, for associations allegedly willfully withholding records.
Yeah.
And Kim and Dana, you can, as you pointed
Do
out,
that all the time.
managers, you have an obligation when you sign up. It's under your contract as well. So please make sure you're communicating as well if you need to.
They may be getting the phone calls from the same association of obviously owners, right, Michael? Like the same ones complaining
I
every
don't
week,
know.
saying we still don't have access to records, because
Yeah.
certainly there's always, like you said, right, some exceptions out there to the rule, and perhaps they're not running, you know, the records requests or the transparency correctly and managing it all under the covers for them.
Yeah, and they did also add a new requirement though, and Dana and Kim, you may be aware of this, but if there are records that you are required to maintain and they're not there, you know, for whatever reason, there is an obligation on the association to, recreate if necessary, relocate them or recreate them as reasonably as possible, as opposed to just saying we don't have the record.
Yeah.
Now, that may not be the case. That may not be possible in certain instances,
It's
and
not.
it is what it is.
Most of the time
You
it's
need
not.
to
Yeah.
make best efforts.
Yeah.
All right.
And Dana, I was gonna ask it, a lot of board members might have this question, who is responsible to maintain the records?
Who is responsible to maintain the records? Good question, Kim. So, you know, the statute always throws everything on the association and the membership and the board members. We, as management companies, are your guard keepers. We should be making sure, and Next Generation for sure, makes sure that all the association records are available. And Kim's going to go through how we execute that to make it easy and accessible. There are the penalties that we discussed that you can go after, but 99% of the time, you as board member, it's responsibility of the association, and that means it's the responsibility of the elected board members for that association to make sure your management company or whoever
Hold them
you have,
accountable.
hold them that maintaining those records for you and are available to your membership.
And there are some other good questions, guys. We're gonna hold those to the end, and we'll go through them as many of them as we can. You stick around because we have a couple other subject matters to get to.
Next slide.
I just want to say I appreciate what Dana's saying there, because these are association official records. Like, take ownership. As a board member myself,
Yeah.
I have these conversations in every single expo that I go to, and they're like, well, the management won't give us records, or the management says they own the records. And I'm like, these are your records. board members. These are
Absolutely.
your association records. Please acknowledge that, recognize that, and do not be led in the direction that you think the management is holding on to the records because it's theirs. They're your records.
Exactly. And how do we make sure that, you know, the association is in compliance and we're assisting them? When we take over an association, part of what we do is we like to adopt policies to make sure that if there's a change of board, those policies are there to protect the membership and to protect the association. One of the retention policies that we say, let's do written rules, how we maintain the records for the association, and how do we make sure it's available for the membership when there's a record request. So that's part of the practices that we do to make sure that everybody are in compliance. We also recommend to streamline the process when it comes to making sure the records are available to the membership.
Right.
Kim is big about having everything digitized, so I'm gonna have her go through
Hi, everyone.
how she feel, how we do it here.
I'm not sure if she told everyone earlier, but I'm also a board member for my association, so I feel everyone's
Okay.
pain, and I understand a new perspective on how important it is to make sure that any and all information relating to the association is available to the membership. It improves communication and transparency. So first and foremost, when we take on a new association, we believe in digitizing everything. Personally, I believe that paper is a thing of the past, and I think that it can create additional office expenses by continuing to use paper. It takes more time to facilitate processes. So if you are able to have everything be digital, say if you have a purchase and lease application, have that be online. If you're able to have your reservations or car decal purchasing, anything that you normally would have in a paper format, if you can make that digital, I highly recommend that because it will improve your processes. And by digitizing everything, you'll be able to have it available in a centralized cloud-based location, which means it'll be properly secured. It'll help ensure that any personal and private information that's obtained is secure. And And I also, if you can, would encourage everyone to get a mobile application that has direct access to your association website. Studies have shown that to reach homeowners and other residents, that the key way to reach these people would be to via text message or on the phone. Everybody's on their phone versus having it the old way of having everything received via mail. So if you want to be able to have people interested and participate in what's going on in your association, having it available through a mobile application would be the route I'd recommend. On the next slide, we'll go over how we as Next Generation use our mobile application to enhance our transparency. If you can, I would also recommend using AI in any capacity that's available. It helps to improve communication, which also can take the load off of your board members and your property managers by having AI be able to relay information and documents to residents who have specific questions. And as we had previously discussed, meeting minutes are an association record, something that you want to make sure that you maintain as well as post on your association website. And Zoom in particular offers an AI reader, where if you have it enabled during a seminar or a board meeting, it'll be able to record and recite the information that's obtained. So that way you can summarize it more efficiently and faster into your meeting minutes, which I think will free up your managers as well as to ensure that they are approved and ready to be approved for the board.
Yeah.
And then post it on the association website.
So what, to translate what this generation is talking about is that when you're using Zoom for your board meetings, even if you have your board meeting on the property in the clubhouse, we recommend to allow we want always the more membership coming to the board meeting, the more transparent you are as a board member, the less questions they understand what you're doing, how hard you're working on the volunteer work. So we always want to encourage more members to attend the board meetings. So if you allow also to have a Zoom for the members to join, as well as being at the clubhouse, you can have that read AI, and that AI tool takes everything that was discussed at the board meeting and voted on and gives you a script. Therefore, the next day, the manager just goes in, selects the motions, and the minutes are populated immediately to be approved at the next board meeting and posted on the website for the membership.
Yeah. And just because with regard to board meetings, guys, it's the board meetings, as far as we recommend that even if you desire to have a board meeting primarily virtually, that you should have it do a hybrid version.
Yeah,
Exactly.
hybrid.
And
That's
what Kim is talking about, so even if you just said to your manager, hey, we'd like you to put your office as a location, so if anybody wants to attend because they, for whatever reason, can't access Zoom, they can't say we couldn't attend because it was only Zoom.
Yeah.
But at least have a physical location as well as a virtual location. That's recommended. Membership meetings, if you're going to do them virtually, you're by law, you're supposed to be announcing at a board meeting that you're going to hold a membership meeting virtually, and also setting up processes to ensure how the owners are going to be able to attend, if there are votes being taken, how that's going to work. Communicate with your council. That's something people don't know. If it's not a state of emergency under the law, you're not supposed to be doing just virtual meetings. One of the things we could also do is you could amend your bylaws, though, to allow for virtual meetings if the membership wants to support it. So these are all things that, little notes to take on this, because there's a lot to talk about.
We're seeing it as at a high level, just what I want to add to this conversation, right? Those hybrid meetings, those membership meetings. For those on the call today, like scared of Zoom or virtual meeting platforms, don't be. And then for those scared of AI, it's not the Terminator 2 coming through the screen.
Maybe.
I've seen the transcripts. You still are welcome to review the minutes and what it is summarizing. Do not be afraid of it. It's actually here to help. We're seeing more hybrid meetings, Michael, Dana, and Kim than ever. And it's funny because we're past, right, that whole COVID stage. I think it turned on a switch that owners were allowed to use. And they're like, well, wait a minute. Some of us don't even have clubhouses, as is the case in my community, right? So why are we driving to a local dealership 20 minutes? Why are we driving to offices? Let's have a hybrid option and allow most of the owners to tune in and chime in like their part.
Chime in, increase transparency, increase communication.
Absolutely.
I think it's a win-win. Next slide, please.
So we wanted to show you in discussion of streamlining processes, just what other softwares and systems are out there that can help homeowners receive the documentation and information relating to their community. So the screenshots that you see here, Next Generation Management, every homeowner and tenant will get a login portal to their own app version of the app, which is an extension of their,
Secure login.
it's a secure login, yes. That has to be verified before anybody logs in. And it's an extension of the association's website. So it basically will mirror the information that's put there. But the first picture just shows the login screen. The second one is a dashboard that'll show the homeowner balance, any pending work orders, ARC requests. It also shows if they have any violations. If there's a board member, there's a whole section available for them to see everything that's going on with the association relating to pending ARC violations, work orders. The fourth slide picture, I'm sorry, shows the association calendar. So in efforts to increase transparency and making sure that the association knows what's going on, I highly suggest that anything that you have going on relating to, it could be annual meeting, budget meeting, it could be bulk trash, it could be bingo night, that you put it on the association's calendar so everybody's aware and they have access to it. We also utilize AI in our mobile application. Our AI technology is referred to as Sunny AI. And what it does is it takes information, it reads the documents in the association's website and it translates that information into responses that homeowners may have for questions. So in the second to last slide, that example says, when is bulk trash? And then Sunny is able to relay the information that we put in the association website to tell the homeowner that bulk trash is every second and third Friday. Make sure you leave your trash out the night before. So this information is amazing in terms of you can find out what your account balance is. You can find out, how many days notice do you need to have in order to have your annual meeting. It will give you all that information. And it really does help board members, managers. If you have a management company that has a client relations team, it helps reduce the amount of calls because homeowners are able to get the information themselves. And it actually cuts the time in half of them to receive the information because sometimes there might be delays in responses and figuring out that information, but they'll be able to ask Sunny themselves. Go ahead.
And then we also have all the documents that are required by statute on the app accessible to those homeowners. So our recent document requests, we basically refer them to the app, make sure they have a secure login, they can log in. We said, if you're not sure, ask Sunny, I'll tell you where the document is. And we've been able to facilitate document requests through the app for our association. So it's really a great tool to have to make sure you're in compliance with everything we're really addressing today for your association.
And personally, I mean, from our experience, I think by having all the access and availability that we do have, it's rare that we get document requests anymore because all the information is available and we make sure that the membership is educated on where they can find these things themselves. So I think it really does free up time and make a difference.
Yeah.
For those of you on the Q&A asking, does Sunny make you coffee in the morning or pick up your dry cleaning? No, it does not.
It's almost there though. I think that's in one of the updates.
Let's just be happy with what it's doing.
By the way, we named him Sunny.
Yeah.
Well,
Sunny,
that
South
was
Florida.
good stuff, guys. And but we're going to move on to the next subject matter. Like I said, if there's some questions that's on that first subject matter, we're going to wait till the end to address those. We're talking about updating your governing documents. And we're not talking obviously about the recent legislative updates because that could be 3 hours in and of itself. I have highlighted a few recent changes that are pertinent to the conversations we've been having, but the importance of updating your governing documents, it ties into legislative changes. And because when laws change, that may end up having conflict. Your documents may have some conflict, or they might they end up being outdated. On the one side. On the other side, as we'll get into, it may not be the updating of your documents may not be something that you depending on how you want your documents to be updated will depend on how those legislative changes would impact. So let's get into that a little bit. Let's go to the next slide. Okay, so to start with, we have the hierarchy of governing documents, and we listed out both condominium and HOA. And the hierarchy is the same for both. Each community association has essentially 4 governing documents, and started in the top of the hierarchy would be your declaration, your declaration of condominium, or your covenants and restrictions, and they have similar names. Some are covenants and restrictions, some are restrictions and easements, but essentially that's your declaration. That dictates how you live in the community. It's your Bill of Rights, if you will, governing how the residents live in the community. The articles of incorporation and bylaws, they are documents that created the corporate entity itself, and primarily should be there. The language contained in there should basically dictate how the corporation itself is run. Your size, size of the board, quorum requirements, notice requirements, things of that nature. And then you have rules and regulations, maintenance standards and policies in the condominium world. You might even architectural guidelines. Those could be for obviously those are interchangeable for both. But rules and regulations most often can be approved, adopted, amended, updated by the board alone. Some communities we work with have language in their governing documents that require a membership vote to even adopt rule changes. But primarily those are the board has discretion on the rules. Changing your declaration, articles, bylaws, most of the time you'll need membership support. I have seen some bylaws that do allow the board to amend bylaws just with board votes alone. But primarily when you're looking to amend your declaration, articles, or bylaws, you're going to have to go out to the membership and get its support. The checks and balance on the rules, and you're fine there. The checks and balance on the rules is that even if the board has the authority to adopt rules, those rules cannot conflict either expressly or by implication with the declaration, articles, or bylaws. And therefore you need to know. So, and again, as I said, since those need membership approval, that's kind of the checks and balances. The board, if the declaration is silent on pets, that's usually the example I go with. There's no restrictions on pets in the declaration. The board is not going to be authorized to now create a rule that says we are not allowing pets. That would be a conflict. That would be a conflict that rule would be subject to being challenged on enforceability. Okay, so with regard to updating governing documents, again, this is going to be. I'm going to try to keep this. I know we went a little long on the first part. We're going to try to keep this to 15 minutes or so, and I have a few true/false questions I'm going to pose. Okay, but we have a class that we teach on updating governing documents, which is an hour minimum in and of itself. There's a lot going on there. One of my colleagues actually taught it earlier today. If you missed it, I'm sorry. But again, go to our website. It's on the chat box, and the calendar of that actually is linked in the chat. And you can go there and you can sign up for any of our classes. They're all free to attend. Whether or not you're a client of the firm, we do not charge for your attendance at our webinars. So feel free to attend any of our webinars, get some good education.
Michael,
Okay?
I always like to explain one thing. I know
Yes,
it
sir.
might sound silly to you, but I think it's important. In every association, there's two types of votes. There's a board vote and a membership vote. When Michael says the membership has to vote because the board can't just change that there's no pets, it means that we're changing our declaration. So that means we're actually doing a change to the rules of the association.
Not the rules, the declaration. You gotta be careful. Declaration and rules are two different things.
Shouldn't have to vote to make that change. The board can't make that change alone because we're doing a change of the declaration.
Right. Right. So right. So that's, as I said, that when if you need membership approval, the board is the one who is going to propose the change. They're going to review it at a board meeting and approve to send it out to the membership for the membership to either decide to support the change or reject the change.
Yes.
Would this include pickleball courts out there, Michael? Those are hot topics.
Well, that is, it will include pickleball courts in what rules to the pickleball courts. Typically, a pickleball court is common element or common area. So know that usually the board would have the authority to adopt reasonable rules governing pickleball courts.
Right.
As long as they're not, but it's not.
He meant if you want to take, he meant to change the
tennis court.
The tennis court to pickleball court.
Changing a tennis court to a pickleball court, that now gets into material alteration situations potentially. So that's a whole other subject matter.
Exactly.
All right. So let's get into a few, I have 4 or 5 slides on true or false common misconceptions. Okay. So let's look at the next slide. Okay. A foreclosing lender is required to pay 1% of the original mortgage debt or 12 months of delinquent assessments. Okay. That is what the statute provides, but that is not a mandate, okay? Your governing documents may contain language that provides mortgagees with greater protections than afforded by statute. Typical mortgagee protection clauses relieve mortgagees from owing anything if it acquires title as a result of a foreclosure. This is what we call, quote, bad bank language. This is one of the main reasons. If we are working with your association and we're handling and you get a bank foreclosure, we will then review your documents. And if we see that, unless you'd asked us to review it previously, and we see this, we alert you to this. This is one of those amendments that the entire membership should get behind, because the association could lose out on funds if it has language that says when a bank takes title to a unit or parcel in its own foreclosure sale, it does not owe anything prior to its taking title. The statutes would allow you to collect the lesser of 12 months delinquent assessments or 1% of the mortgage. But if your covenants say 0, then it's 0, and the banks know this. Worse is if it says that a third party won't be responsible for anything until after from the date they take title forward. Because third parties don't generally have this limited liability. They know everything that's past due. So you will definitely want to get with your association counsel after today and ask them, hey, do we have this bad bank language? And if you need counsel to review that, again, I know someone who can. All right. Next item. All new owners must go through the screening process in our community. That is also false. Okay, this is document specific. You may want to amend your documents to authorize for approval or disapproval of new purchasers, new tenants, and what other types of transfers can be screened and approved. Okay, do you want to have all transfers screened and approved? And I would offer that because I would suggest that is how you want your language drafted. You don't want to limit it to just sales. You want to limit it to any transfer of title. We had a situation, a case, not our associate firm, but a case that came out where the language of the declaration was specific to sale approval rights. And it was not a sale, it was a quitclaim deed, a gift from a family member to another family member. What happened in that situation is that second family member was disapproved because they had a long criminal history that would disqualify them under the governing documents. So a new family member came in who didn't have that history, and they bought it, were approved and bought it, and then they gifted it to their other family member. The association attempted to disapprove it, and the court said your governing documents give you the authority to approve sales. It didn't give you the authority to approve gifts. So we strongly urge you to consider, if you have the ability to approve now and it's not comprehensive, you want to look at updating that. Okay? If you don't have approval rights, you should not be doing applications and asking and doing background checks. You should be talking with your counsel about updating your documents to add those approval rights, whether it's for sales or leases or any other transfer of title.
So don't run it like the Wild Wild West, is what you're saying.
Correct. Okay. Go back real quick. Okay. Just take a look at the number 2, many mortgagee protection clauses prohibit the association that screens anyone that buys from that mortgagee, meaning that if a bank takes title, they can sell it to anyone. You don't have the right to screen or approve. You got to check your documents on that. That's not something you're typically going to be able to amend out, but you check with your counsel. And then if there are certain parties that might be exempt from approval process, like spouses, children, parents, you want to know. It's document specific, so you need to know. It's not just because you live in a community you have that right. All right. And board members, you need to let the membership know if someone complains, hey, why did you allow this person to move in because they have a criminal history or they cannot afford to live here? Well, if you do not have approval rights, then you need to let the membership know our hands are tied. If you want us to be able to protect the association and make sure people are properly qualified, then we would then approve an amendment to give us those rights. All right. And you want to have counsel definitely draft that with you. Next. Okay. Once the law changes, the change is automatically applicable to your community. Okay. This is not necessarily true. This is also false because there are instances where the law will apply, and especially if the law is considered procedural or remedial in nature. However, the law cannot change fundamental contract rights unless there's a compelling public policy need. And that is something in the HOA world today that has come up because in 2024, Tallahassee approved and the governor signed legislation in the homeowner association communities that prohibits you from restricting owners from parking a commercial vehicle or a truck on their driveway. And we have HOAs that say, wait a minute, we have language in our covenants that restrict parking of commercial vehicles or trucks. And I'm being very general in nature, guys, not specific, okay? So can we enforce those? and there is a potential legal challenge that an HOA can make that says we want to continue enforcing those because we don't have language in our documents called Kaufman language, okay, that would make these new changes in the law apply to our HOA. So you need to communicate with your association council as to whether changes in the laws apply to your association or not. Okay? Kaufman language is the language that's called, as it's written, quote, as it may be amended from time to time. So if your declaration has language that says, my homeowner association is subject to chapter 720 Florida statutes as it may be amended from time to time, then that means the amendments to the statutes would generally flow and apply. If you don't have that Kaufman language, those new changes would not apply automatically. They might if they're considered procedural or remedial, or there's a compelling public policy. It's a technical legal analysis that you'd want to get with your council, but don't presume automatically changes in the law apply to your community. Next.
It's a big one.
Okay, the board must obtain a vote of the owners before making any material alteration. Okay, that also is not automatically true. Governing documents may contain enabling language, meaning that there might be, like I have a community I was just talking with, the board has the authority to make a material alteration change up to a certain dollar amount without a membership vote. We lost Kim and Dana. Do be aware that your documents may contain enabling language. You're gonna, again, if you are considering undertaking work, welcome back, guys. If you're considering undertaking work that might be considered material alteration, you absolutely, and this is to your management team and your board members, this is something you want to talk to council about. You don't want to proceed with a project and find out later you should have had a vote. Okay? Necessary maintenance exception might apply as well. Simplest example I can give you. You have a roof that you have confirmed needs replacement. You have a roof consultant or engineer that says, yep, roof is done, you need to replace it. Replacing your roof would be considered necessary maintenance, and you would not need a vote of the membership. But if you decided you had a shingle roof and you're changing to barrel tile, that change in material would require a vote of the membership if your governing documents do not contain enabling language. The statute would require it. Okay, so do be cognizant of the fact that you might have a necessary maintenance project that has a material alteration aspect, and that's why I'm saying it's important you get with experienced counsel and review those items. Okay, with HOA limitation on expenditure, otherwise that could apply both HOA and condo actually. All right, next one.
We've gotten that for pools and condos. Definitely has come up on the material alteration votes, pools and condominiums. So be aware.
Yep. Okay, that was actually before. Okay, so before we jump into annual meetings, anyway, that is the last item. But again, I think what all of you can see from those five questions alone, there are very good reasons to be looking at updating your governing documents. If there haven't been updated in more than 10 years, you certainly might want to look at doing a complete update of your documents. But even still, you can get an analysis done. We do that all the time. We analyze the governing documents as a whole, give you guys, the board and management team, a letter that goes over all the different changes that you can consider, and then decide, do you want to do everything or do you want to pick and choose a few? But there are a lot of good reasons to be looking at your governing documents. You know, projects, we typically think about construction-related projects. Well, one of the projects as board members you should consider budgeting for is reviewing your governing documents and having them updated to bring them current with Florida statutes, Florida case law, and just the nature of the way you live in your community. When the developer created these documents, they developed these documents to have them sell the units or the parcels, not to live in their community. So keep all that in mind.
Just want to add to that, Michael, we get a lot of calls on brand new communities as well, right? So developer language in those documents, brand new community, not necessarily 10, 15, 20-year-old documents, and they do not like the language that the developer has in there, and they're obviously looking to amend those as well. So for folks on this call today, understand you may be in a brand new community. You may still be smelling the paint that's drying, and you already do not like some of the governing documents for your community and want to make some changes, obviously, or bylaw amendments.
Good point. Yeah, and that's one of the things when we work with associations helping them turn over from the developer. Obviously, we talk to them about construction-related issues and that, but we also talk about they need to review their documents and determine, are there issues, are there sections of their documents they might want to update? Because to my point, Those documents are created by the developer and developers council to sell those properties, not necessarily the way you want to live in the community. And that goes the same for rules, by the way. You want to be looking at your rules, and you want to have your association council review your rules before you even update your declaration, articles, bylaws, because you need to know, are my rules enforceable? Remember the example I gave with the pets. If you want to have a rule that says you can restrict pets, you need to add some kind of amendment to your declaration that allows you to enforce that rule. So it's a big project, updating documents, something you want to talk to your team about.
Excellent work there. All right, folks, you've hung in with us this long. Give us a few more minutes here. I'll make it quick and painless. We're going to discuss here online voting, electronic voting. It's a super hot topic, piping hot here. You've got to grab a piece of charcuterie somewhere and a glass of wine. Please do not let me stop you in your homes. Again, we're going to get through this stuff fairly quickly, right? Electronic voting. What is it? I think generally speaking, right? Everyone's like, oh, someone's voting electronically. Well, there's a little bit more that goes into it, and we'll discuss it these next few slides. It is voting that uses an electronic mean, right, in the general, and it is, to Dana's point earlier, typically a membership-based vote, right, being used out there. There's different types of electronic voting, specifically here in the state of Florida. What do we call those? Well, they're required, for example, advanced ballots to be sent out in some of these situations. So a ballot being out before even the day of the meeting. What we call proxies out there, right? So electronic proxies can be used in the electronic voting world. And then for my 720, typically my older HOAs out there that still have nominations from the floor and only voting the day of the meeting, or a general proxy being sent out to owners, we've got real-time voting requirements, right? The day of as well. All of those possibly folding into what we call electronic voting. Why are we using this? Why is it such a hot topic these days? There's a ton of reasons why you should be looking into it if you haven't already. And we'll get into, some of the statutory language in just a little bit. But look, folks, this has been around for about 8 years now, right? It's no longer brand new. It's certainly got obviously heightened through the pandemic. And there's a ton of great reasons why you should be considering electronic voting in your communities. Some of those are increased participation. We see generally from 20% paper-based voting to 60 and 70% participation electronic voting. Reduction in printing and mailing costs, massive one there. You can send out a lot of these electronic notices if you get an electronic notice of consent from these owners, in addition to an electronic voting consent as well. Efficiency. No one spoke more to efficiency, at least in today's meeting, to me than Kim, even though Dana had to translate, obviously, what she was saying for all of us older folks on the call. But there's a ton of, obviously, efficiency when you implement electronic voting. Reporting and auditability. We spoke to a ton of that today. How do we get some of those reports and auditability? But generally speaking, it's pretty tough to go digging in boxes for older ballots, right? Electronically speaking, that information is available real time and usually stored in a cloud-based environment. Transparency, believe it or not, it is more transparent to vote electronically these days than it is to obviously fill out some sort of paper-based ballots. And on the security side, believe it or not, for some of those on the call today, maybe wondering, well, is it secure? It is. There's a ton of enhancements. There's link encryption. There's token-based voter authentication. There's quite a good amount of security, the likes of which you would never get on a piece of paper unless you have some sort of forensic signature experts on your staff. The security for sure on the electronic voting side.
It actually ends the corruption.
Yeah, definitely on that side. So how do we get started, right? For, again, those folks on the call today wondering, how does this even begin for our communities? Well, I have great news. I get up this question a lot, so I'll get right to it. Most of the associations are under the assumption, and these are for my condos today on the call, my 718, 719, some of those co-ops still in the state of Florida, and my 720s out there as well. They asked me, do we have to amend the bylaws? And the simple answer here is checking with the association council, but no, right? For the most part, the statute has made it pretty clear and easy. They've stated, look, you've got a corporate resolution to pass, a resolution which does have a 14-day notice requirement to the board. So board votes, 14-day notice requirement to the membership, letting them know that the board will be voting on a resolution to adopt electronic voting in the community. So yes, the beginnings of this is a board vote on a resolution. What comes after that is, generally speaking here, we've got to get owners or members opted into electronic voting. By default, they are opted out. Just to make it clear, we are going to have some folks banging down the door saying they will never vote electronically. And by the way, they all have Facebook and Snapchat and everything else, but they don't want to vote electronically. That's fine. That's okay, right? and someone will say, we don't have an email address. And you're like, yes, I just saw your post, online on social media. But again, their prerogative, right? They stay by default opted out. That's the good news. We've got to get owners to opt in and get with an electronic voting provider that will assist your community in getting owners to opt into electronic voting. So there are requirements out there, statutorily speaking. Again, we've got the statutes there. That's 718.128 for our condos, 719.129 for our co-ops, and again, the 720.317 for our HOAs. Simple Google search will take you right to that language. I encourage you to also check in with your association council.
Just to translate, Frank, for a minute, you don't need to amend your declaration to do online voting for amendments or for your annual meeting.
Correct.
The statute gives you the guidelines and you can do it without needing a membership vote to do that.
Absolutely. There's a board vote.
We can start it right. We can do it to start it today for your association.
Absolutely. Board vote only, folks. And again, we'll get owners to consent or opt in. Good news out there is the following. Technology is trending, right? Generally speaking, what we see is 32% of the communities in Florida already have documentation permitting the use of electronic voting. It's a long way to go, folks, because Florida sat on this for a while, right? Before the pandemic, so 2016, electronic voting is already allowed in the state of Florida. As typical Floridians, because we're super busy, right? We sat on it and we were like, not today. And then, of course, pandemic comes in and we're like, where's that electronic voting statute? I think I saw it somewhere. I left it sitting on my desk, and we go right into electronic voting. So good news, we're certainly catching up. The legislation was obviously helpful in that sense. And again, big takeaway for everyone on the call today, the participation rate jumps, folks, from 20% to 80% on average with electronic voting. And yes, for those in the call today, living in those 55 and better communities, there are absolute case studies I would love to share with you. So feel free to reach out. They include the likes of Century Village, all right, for all those Floridians out there. Century Village at 82% currently for electronic voting. And I feel like if they can do it, we can all, right? I almost fell out of my chair when I saw that participation, right? So online voting, here's a case study that we've got out there in Deerfield Beach, just to kind of
That's
go.
me.
Yeah, go for it.
It's just my community, Frank. I'm sorry.
I want to hear it go.
Okay, so as next generation and as me as an individual, I always put my finance glasses on and I always want to know, where is it saving? How can we increase revenue? What can we do better for our association to be financially stable? Because as I mentioned, I came from finance into this industry. So whatever legislation says, I translated what does it mean money-wise for my associations. So we do have a 55 and older community in Deerfield. It's 435 units. We initiated the online voting, initially not for annual meetings, actually to do amendments for that association. Before there was online voting, the platforms that were easily accessible, we amended the declaration for that association with the paper route. That whenever there's a resale, this is an HOA, it's allowed, it's only in HOAs. Whenever there's a resale happening, meaning one homeowner is selling to another, we don't care the buyer or the seller, they have to pay the association $2,500 capital contribution when there's a transfer of sale. That amendment brought in 2023, $180,000 to the association, which offset any insurance due to the increases, increases in their maintenance fees for the following year. So this is a great example to tell you we did that in paper. And then we said, oh my God, we got this established in paper, 435 units. We got 70% membership vote, 75% membership vote to do that amendment when we did it on paper. What can we do if we're going to use online voting? So we tried it out. Our document requests 2/3 of participation before we can do anything. We initially had 125 residents registered for online voting, and we ended up having over 258 online voting. What did we vote for? We placed in the bylaws amendment that we reduced the votes from 2/3 to 50 to majority, which is 50+1. So we no longer need to do 2/3 of the votes to do any changes. So that already makes it easier because declarations are 40, 50 years old, and you want to always update them according to the changes in legislation. We also passed an amendment, what Michael discussed, adding the Kaufman language, meaning if there's updates in the statute, then it's going to affect that association. And we also passed an amendment that what also Michael discussed, that has to do with the purchaser in a foreclosure. Now they have to pay for the association when they buy the home with foreclosure. The next thing we're gonna do is we're gonna add the 2,500. Also, if there's a transfer of sale and a quitclaim deed, and that's gonna bring more money to the association. So we tell you not only to take the tool for the online voting to do your annual meetings, use it to update your declaration, and it's possible in any age association as long as you're determined and you really want to make that change because you can make a difference in your association. Next slide. We have identified also that there are savings in the printing and costing of an association when it comes to when you're already when people opt in for electronic communication. So then you don't have to mail them out those notices. So if an annual printing cost is about $7,000, we notice that there's a 70% savings in that office printing cost for that association. It may not sound like a big amount, but every small amount adds up to a large amount, and we do what we can do to save money for our associations.
And that's big. So don't discount that at all, Dana, because on the contrary, you've got 4,000 unit associations out there and 19,000, some in Fort Myers, right? 5,000 unit associations. So the bigger it gets, obviously, the bigger the savings.
Yeah, the cost is much bigger. Yeah. And the more you can have them enroll into electronic communications, you're not going to have to mail it anymore. Second notice of annual meeting.
It's a big one.
It's a big one. So when you start implementing online voting, you're saving a lot of money for your association. Next slide. Wow, we made it to the end.
Yeah.
I guess we'll start by thanking everybody for staying later than anticipated and reminding everybody that there is a survey at the end. I remember, Jeff. And that also we will be sending everybody a copy of this presentation. I don't know if
I don't know if you want to maybe quickly just skim through the questions.
yes, I was
Yeah.
just
If
I was
there's any
just
questions,
about
you-
saying that maybe we should go through some of the questions.
Yeah.
Michael, see if you can give answers real quick because I for some reason don't see them.
Yeah, we don't see the question. Oh, Q&A.
It's
Oh,
under Q&A. You got to open the Q&A.
oh, okay.
Okay, because and I'll read them and then because I
Okay.
can read them and then you guys can answer.
Yeah, go
Okay?
for it.
And again,
Okay.
if it's unrelated to the topics, guys, I'm not gonna even read it. I apologize. You
Okay.
guys. Follow up with
Okay.
your association attorney to answer that question. That's all. All right. And HOA, can an owner opt into electronic voting via an email or electronic authorization form? The answer to that is yes. That was clarified in the statute. Yes, you can opt in via email. You do not need to. You don't need to send in a written form. It can be done by email. Can the HOA do a push email informing all owners of the electronic option availability using owner email from TOPS, even if the owner is not authorized communication? Okay, so understand what the law currently provides, okay? And that the board is required to adopt a resolution. And for some reason, that is a 14-day notice meeting that you have to mail notice of that meeting to all owners that you're having it. Again, it's something we're trying to get Tallahassee to get rid of because it makes no sense for you to mail a notice to the owners to say we're going to pass a resolution that allows it as an option. You're not mandating people do it.
Yeah.
It's an option. But and then the board has this resolution, and we'll work with our boards and management team to create a package that covers everything and includes the forms that you want to then send out because you're going to need to notify the membership. Hey guys, the board passed a resolution. We've got a third-party vendor who we're gonna, here we go. We got Get Quorum. We're gonna be working with Get Quorum on doing our, electronic voting as an option. If you want to opt in, let us know you want to opt in.
Yeah, and Michael, I think the question is more geared, at least the way I interpret it is, can the association send out a notification letting them know we're going to be offering electronic voting, not a consent form, but even a notification before they've consented to electronic communication. I mean, I do get that question often is which one first, the chicken or the egg? And they reach out to owners via email, ask them to consent to electronic communication, or is that?
No, that's what I'm talking about. But the board first has to approve it. The board first has to approve that they're going to even offer it as an option. And then they send out to the membership, hey, we've approved this. It's an option. Do you want to opt in? The question is, can they do an email to all owners that it's available, even if owners haven't, the way I'm reading it, consented to email as the official means of address? And I'm saying that you should, if the owners haven't consented to email as your official means of address, you should be mailing them out the notice. You can certainly offer it as it then becomes, if you email it as well, that to me is a courtesy. Okay.
Next question.
Oh God, a lot of these questions, guys, are not related. I
The website is
apologize.
created
Let's
now.
For the
see.
unrelated questions, like, is Costco already have Christmas trees? Almost, folks. We're almost. If you go to your local Costco, the holiday stuff
You
is
saw it?
it is coming
Yeah.
in.
Well, yeah. I mean, I know people in my neighborhood have Halloween decorations up.
I do.
How to get they want to know how you get a property manager disciplined for not supplying records. Will the DBPR remove their license? Again, I will tell you, I will say this. It's not in my experience that a property manager ever refuses to supply records. It just isn't. The fact is, but I will say that I have seen too many complaints against a property manager for failing to provide access to records that the board typically then has to defend because they're indemnifying the manager and the management company and explain. And we have to now explain to the investigator what went on and what didn't go on. So what I will say to the management, to Dana and Kim and anybody else who's on here, and if you're not a manager, let your manager know this, that keep good records.
Yeah.
Of that you've given, and someone that you've provided access to these records. You've reached out to them and given them access, because I can't tell you how many times I've had to, I've said, look, division investigator, here's their response, here's their request, here's a response, here's a second response. They didn't show up. Dismissed, done.
Yeah, we've seen
Okay.
those. Absolutely.
Should all owner information requests be reviewed by attorney for confidentiality concerns, excluding litigation? Okay. Joanne asked that. Joanne, again, it's probably would have been if you and I were having a quick conversation, it'd be easier to understand what you're asking there. A request to inspect records does not necessarily need to be reviewed by your attorney. I don't think it's a bad idea to make sure that the process is being properly followed. But confidentiality concerns, what that means is, and there was a question that was asked on the chat that I responded to everybody might have read my answer is, the statute is very clear what official records are considered not open to inspection, that are confidential. And those records should not be available to the general membership. So you're going to want to make sure that you're not giving access to those records. And that's obviously attorney-client privilege, bless you, communication. But there's also, as I mentioned earlier, sale, lease, approval rights, medical records of the owners or residents, okay? Personnel type records that is considered confidential, that shouldn't be part of the official records. So you'll want to be cognizant of that.
Right.
Oh, okay. Nancy has a very long question. Okay. Then Nancy says, we post on the community message board located next to the mailbox the 48-hour required board meeting notices, and it contains the agenda. Mass email sent to all homeowners. Okay. It's all now the statute requires the management company must post the same information on the website. What if we do it and the management company doesn't?
You can have a difficult conversation with your management company.
Okay. Yeah. One thing that
Time
you'll
to find a better one.
Right, there you go. Listen, I will tell you that one of the things that came up earlier was, obligations of the management company. The official records are of the association, but the management companies typically contractually obligate themselves to be the custodians of those records. You want to have your management contracts reviewed by your counsel and make sure you got that these things are in place.
Breach.
Right.
I don't think it's a bad idea.
I can say this with
you
Kim and
oversee
Dana
it.
because I know they're a quality management company.
Yeah.
Management companies that are quality like theirs are not going to balk at your attorney recommending certain language be added that holds them responsible to meet the obligations that you are paying them.
They're licensed to, and they're also licensed to meet.
Exactly. Okay.
I wish there was more
post official
enforcement on
meeting.
licensed
Well,
men.
it says, how do you post official meeting minutes when these minutes must be voted on and approved first? Okay. That's a good question. Now, I will tell you, Nancy, if you have minutes that are not approved, that are up on the website, they should be noted that they are draft minutes, not yet
Yep.
approved.
Exactly.
Simple as that.
Yeah.
Okay.
You're
This might be for any of the three of you, but can you give an approximate cost for a website for a condo with 31 units?
An owner portal? No, we provide electronic voting only, but it's a few bucks per door for electronic voting, generally speaking, per association per year. So as far
Yeah.
as website cost for your association, that's going to vary. How many features do you want? As you see, some of them have mobile features and all sorts of features, and some of them are very simple in nature. It's really just, you know, customer facing with some obviously records stored in there. So there's very dumbed down versions and there's very sophisticated versions. Go out and explore what features you need specifically and what companies.
Okay.
And also with the
Does the
complexity of
mobile
the
app-
requirements.
I'm
then-
sorry, Dana, go ahead.
I said with the complexity of the requirements, you shouldn't just have a vendor, a supplier that gives you the website. You should have a licensed management company to make sure that the documents are there in the proper order required. So
Okay. Does the mobile app translate to other languages like Spanish or Creole?
yes.
Yes.
Great.
And in Sunny, the AI, you can ask it to translate in any language you want, and it'll respond to you in that language. It's pretty cool.
Yep.
Ooh.
Let's see.
I can't understand that one. Okay.
See if I can get.
You can close that
Okay.
frame.
The
See if I can see some of those questions with Michael.
okay. Oh, I see. And you know, and I don't know who anonymous attendee is, but you ask a lot of questions.
I don't know.
But that's okay. If we want to change our bylaws to have a metal roof now as an option, and also metal or plastic fence as an option besides just wood, do we need an attorney to do this, or can we file this on our own as an addendum to our bylaws? It was voted on and approved by the homeowners already. Well, the answer to your question is, do you need an attorney? You are not legally mandated to use an attorney. Do I think that you would be doing a disservice to your association to not at least have an attorney review what you did and the language that you prepared, to at least make sure that all of the language is clear, not ambiguous or unnecessary, that it meets everything that you want it to meet? And I understand it might be very basic, but also that the procedures were properly followed, that you've done everything. Yeah, do I think it's worth spending a few $100s to have a quality attorney review those things so you don't have someone coming back to challenge it later? I do, but it's a business decision for the board. Okay.
How many raised their hand?
We are 35 homes. Do we need a website? Okay. If you are an HOA,
No.
you are not statutorily mandated to have a website unless you are 100 homes or more as of January 1, 2025. If you are in a condominium, you are 150 units or more right now, you need a website. By January 1, 2026, that 150 drops to 25. So if the anonymous attendee, if you're 35 homes means condominium units, you will need a website. If you are an HOA, you don't need a website by statute. Doesn't mean a website's not a good idea though,
Yes.
because it does allow you to help let people get access. Okay. Dominic, thank you. John, thank you. And Frank, I'm going to say this one's a shout out more to you. You guys have a great sense of humor.
You
Yeah.
have to.
That is everything, guys. I want to thank. All right. I'm going to start because I've been talking. I'm going to say, Dana, Kim, again, thank you very much. Frank, thank you guys. Great information. I learned some myself. I always like that. To those attendees who stuck with us the whole way, and most of you did, appreciate your time opportunity. The evaluation link is there. Please click on it. Please send it back to us. That feedback is very helpful to all of us as we put more of these programs together. And if you certainly can use great management, Get Quorum is going to be great for your online voting. KBR, if you have legal needs, we will appreciate your opportunity to give us a chance to sit down with you and talk about why we would all be good for you. So with that, again, I want to thank everybody. And I don't know if you guys want to add anything on your own, but I'm going to say goodnight.
Thank you. Have a good night.
Thank you, guys.
Enjoy your dinner, everyone, if you haven't had it yet, and have a great evening. Appreciate you educating yourselves and just getting a little bit more information out of these. I think they're worth their weight in minutes and gold for sure. So thank you.
All right.
Thank
Thank you.
you.
Good night, everybody.
Appreciate it.
Thank you.